told Jack and Jordan I would say hi tonight.
Great to see you. Yeah, I feel like I'm really good.
Yeah, I know. We see each other. We always see each other by email a lot. So.
Yeah.
First one, huh? I asked them. I said, General said, yeah, send it to me. It's like, it's your first one. And I said, first one. You can go to the first one. I was like, okay. All right. I thought we had one together that we were going to do. And then it just didn't. Yeah. True. Well, fortunately, it's got many cars now. They're like fire and brimstone. So I don't think, just Judge Kilburn. Maybe not. But it's not like her. Chief Judge Rhodes in this. Look at that.
Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Scott Nagar, Judge, presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning, everyone. Welcome to the 5th District Court of Appeal. We have 2 cases on our docket this morning. Each case we have assigned 20 minutes per side. So, appellant, when you come up, please tell us what amount of time you would like for rebuttal. So with that, we'll start with the first case on our docket, which is Kuhn versus Walmart Stores East, 23-3663. Counsel, are you prepared? Please approach.
Good morning. I am Adam Richardson. I represent the plaintiff appellant. I would like to reserve 5 minutes for rebuttal. We're appealing a partially adverse judgment, and we're asking the court to reverse that. It's a one-issue appeal focusing on jury selection, and specifically on 2 jurors who we think should have been who should have been excused for cause. There are 3 points. The first 2 we have the burden to establish, which is preservation and merits, and then my colleague on the other side has the burden of establishing harmless error. That is, whether the failure to excuse those jurors contributed to the verdict. So the first issue is preservation. I believe that we have established that the issue is preserved. And in particular, we rely on this court's case in Guti versus Clevenger. Now, I recognize that that case was partially abrogated by the Florida Supreme Court in Siedler, but the preservation part of that opinion is still good law. So the reason that we preserved our issues today is that, of course, that we challenged both these jurors, Mitchell and Robinson. Both of those were denied. Then we moved on to peremptory strikes, where we backstruck Mitchell, and then we used a final peremptory strike. Importantly, after all parties exhausted their strikes, the trial court read the presumptive panel of primary jurors and said, agreed, not waiving any previous objections or requests that were made. And then we said, correct, Judge. After that, we did what we were required to do. We asked for an additional strike because we were forced to use one on Mitchell, and the trial court denied that. After the defendant asked for an additional strike, the trial court granted each party one. We used ours on a prospective juror, Widner, who had earlier in jury selection expressed the same kind of reservations about the burden of proof on non-economic damages. Then we asked for an additional strike to use against Robinson. The court denied that. Then we moved on to alternates, and we asked to be able to use the alternate against Robinson. The court said, I get that you did that, but no. And then after that, we used a strike against the alternate. Parties agreed to have 6 jurors and no alternate. The trial court and the clerk confirmed the list of jurors, excused those who didn't make the jury, and then the jury was sworn in.
Counsel,
Yes.
The distinction seems to be, you agreed to go with 6 jurors. You didn't renew it at that point. Isn't that different than just a brief passage of time, as some of these cases have indicated? You agreed to go without an additional juror. That's a difference, knowing that Robinson was still on the panel. And what supports that?
Well, I believe that first the case from this court, which is Guti, and then there are a couple cases from other district courts. So in Guti, this court held that the issue was preserved when when the jurors were sworn in only a few transcript pages after the objection was made.
Right, but there wasn't a significant concession that you were going to proceed without an alternate or something like that. It was, like I mentioned, it was a brief passage of time. I think the third DCA case was similar. This seems to, that's a big deal to go without an alternate and a jury.
Yes, ma'am, it was, but we still had what we contend was a compromised jury panel because Robinson was still on. At that point, even though we agreed to go without an alternate, we didn't have the ability to go back and challenge or strike Robinson. He would still remain on the panel.
Right, but you didn't renew your objection at that point. You didn't say, yes, I agree to go with 6, but I still maintain that that I would have struck Robinson or anything like that. It was just an agreement to go with 6. Is that right?
Yes, and I think that is going toward the Joyner case where, like you say, we didn't renew an objection at that time, like immediately before the jury was sworn in after we agreed to go with 6. But some cases have, I wouldn't say created exceptions to the Joyner rule so much as distinguished Joyner. For example, the Goatee case, there's a 4th District case, Langen, and the 1st District case, Smith. In Langen, and I think this is important because I talked about the facts just a bit ago, the 4th District noted that the trial court indicated the issue would have to be resolved on appeal. So the main issue for preservation in this context is whether the record suggests we have abandoned or waived our objection, whether we have misled the trial court or our silence has misled the trial court or the other side into believing we've abandoned that. But at this point, by this point, we had already made our cause challenge. We tried to strike him. We identified him repeatedly to the trial court. The trial court also said that not waiving any previous objections or requests that were made, which makes the case similar to Langen. So I don't think that anyone has to speculate about whether we abandoned this specific challenge. I think it's fairly clear from the record. What the Walmart relies on is a case from the 4th District Court of Appeal, Spencer versus State. And in that case, and this was sort of like the 3rd District case that you were talking about, there was a gap in time between the objection and the swearing in of the jury where there was additional discussion among the parties. So what happened was the parties in that case continued exercising strikes, and this is critical, making selections that affected the composition of the jury. However, in our case, what happened after our objection, our final objection, was just alternates. And as you said, we just agreed to go without an alternate. We had the 6 jurors already. No changes in composition were made to the panel of primary jurors. So for that reason, we think that Spencer versus State is distinguishable. So for those reasons, we think that we have adequately preserved this issue so that the court can consider the merits arguments. On the merits, the Florida Supreme Court has been very clear since Singer in 1959 to Mataran's later, I think in 2013, that if there is any reasonable doubt, if there's a basis for any reasonable doubt to believe that a juror can be fair and impartial, that juror should be excused for cause.
Our review is for abuse of discretion. You would agree with that?
Yes, sir. There's something interesting in the cases where they say it's a mixed standard of review, abuse of discretion for some part of it and law for another, but I didn't see that developed in any of the cases that was cited in our briefs.
Given the nature of the question posed by Ms. Kuhn's counsel that seems to be central, and that is, would you require, to the 2 jurors at issue, would you require a little bit more, I think was the phraseology.
Something like
that. Why is not the trial judge in a better position in presiding over the trial and jury selection and being in the room and hearing the question and not only listening to the jurors' responses or the prospective jurors' responses, but observing the demeanor and the interaction? Why is the trial judge not in a superior position to our chair such that we should defer to the trial court on this matter?
Judge Sood, there is a tension between the articulation of the standard of review and how the cases actually come out, including the substantive standards, Singer, Mataran's, and other cases. I think that what the courts have done is they've stated that there's a standard of review of abuse of discretion, but in practice, and we see this in a bunch of the cases that we've cited, including from this court, they've been less deferential than in other discretionary matters. So what the courts do is they have the standard of review, but they have that substantive standard where it's reasonable doubt. Close cases should be resolved in favor of excusing the juror. We don't take subsequent professions of impartiality as dispositive. It seems like although the trial courts have that discretion, and that's a standard of review, in practice it seems kind of limited, that the courts engage in a rigorous review of the transcript usually, it's just a transcript, and not grant no deference to the trial court, but kind of hold them up to what the substantive standard requires, because there's a constitutional dimension, the right to a fair and impartial juror. I suspect that's what's going on, but I don't think I've seen that articulated in any of the cases. So while I do agree that this court reviews it for standard of review, the standard for the abuse of discretion, I also don't think that it carries as much weight in these juror challenge cases as perhaps in other ones. Did that? Okay. Right.
And counsel, it seems like in this case, it's almost a classic case of the jurors say, well, these are intangible damages, non-economic pain and suffering type of things. And I think to jurors, they typically think, well, I need something more than just someone coming in and saying, oh, I hurt, I feel pain. They want something objective to look at. And that's what I see them saying in their initial answers. So I want something more, yeah. But in the end, at the end of the day, they're all asked, you're going to follow the law, aren't you? And they all said yes. Something to the effect of, I don't necessarily have to like it, but I will follow it. And we judges, sometimes we don't like the law, but we have to follow it. So I'm not seeing exactly where the prejudice is here, where they expressed dissatisfaction, but then in the end said, well, I'm going to follow what I have to follow.
Yes, Judge Makar. I think that the specific jurors that we're talking about, Mitchell and Robinson, present a little differently for one reason. The plaintiff's counsel asked that question, would you want to see something more than greater weight? Both of these jurors said yes. But then after the trial court then explained what the burden of proof required, and it was actually kind of an extensive statement to the jurors. And even after that, these two jurors said yes, they would still want to see something more, and then yes. And after that, after the plaintiff then questioned one of the jurors, I think it was Robinson. So only after that, two instances where they insisted that they would want something more, upon defense questioning, they said, yeah, they could follow the law. I think if maybe we had where the plaintiff's attorney just said, would you want something more than greater weight of the evidence? And then it was explained to them what was meant, and then they said, yeah, I can follow the law. I think that would be a fair denial of a cause challenge. But it's the two times when they insisted that they would want a little bit more, that we should be skeptical of their later assurances, especially because at that point, later in the jury selection, they probably kind of got an idea of what answers they should have given, which is something that the district courts, and I think the Florida Supreme Court and Matarans talked about, where, yeah, they'll give the formal assurances, but they think maybe it's because that's what's expected of them. It's not necessarily that they have really put aside any misunderstanding, or I don't think it was a misunderstanding, but a statement that maybe they wouldn't be able to follow the instructions on the law that the judge gave them.
What evidence was put in on the non-economic, the intangible damages?
On intangible damages, the plaintiff gave a lot of testimony about that. I think two of her children also testified. So that was on our side, the pain and suffering evidence. The other side, of course, put on their evidence. I think they put on about 23 minutes of surveillance that they'd taken, and that I think that went toward their argument that she's really not as bad off as she says she is. Look at her; she's not experiencing any loss of enjoyment of life.
The judgment was for $100,000 on economic damages or loss, and you're asking for a new trial just on the pain and suffering?
It's no, Judge. I think what it is, it was $100,000. It was $75,000 for past medical damages, and then $25,000 for past non-economic damages. But but I think in this case we would ask for a new trial on all of the damages. I think we can safely say that negligence was established. They already agreed that they were negligent. That issue didn't actually have to
Okay,
go.
so I misunderstood. They gave her some pain and suffering for past pain and suffering, but not future.
A lot, yeah, they gave her a lot less for past than she asked for and nothing for future. That's correct.
But they also gave her less for medical damages than was requested, correct? It wasn't just pain and suffering.
That's correct. I think in the closing argument, that Walmart said, gave them a bunch of different options. If you go with us on this, you can do this. If you go with us on that, do that. And that was basically the best case option for them if it was a plaintiff's verdict, which is give her something for the past, but don't give her anything for the future. Certainly don't give her as much as she's asking for on past medical damages.
Could a reasonable reading of the record lead a judge reviewing the case to conclude that the prospective jurors saying they might need a little bit more, paraphrasing their response, that they might need a little bit more was addressing only Ms. Kuhn's testimony and not raising the burden of proof per se? For lawyers and judges who have ever presided or litigated a case before a jury, in jury selection, once you start talking about the various burdens of proof, whether it's reasonable doubt or greater weight of the evidence or clear and convincing, sometimes prospective jurors, their eyes may glaze over. We're talking about legal things that they may not be able to key in on as well, the distinction between those. And I'm just wondering, in reading that record, perhaps, as a prospective juror talking about, I'm going to need a little bit more than just the plaintiff's testimony, and maybe 2 other children do that, maybe video does that, what have you. But I was questioning that, and then I just thought, well, doesn't the trial judge have a better understanding being in that courtroom while that is taking place? But could the record perhaps reflect the prospective jurors discussing the quantum of evidence rather than the burden of proof?
I think it could be read that way. I think actually one of plaintiff's attorney's questions was about that, like, would you need more than the plaintiff's testimony? I think the implication was, would you need maybe medical evidence confirming that she has certain injuries?
So if a reasonable reading could lead to that conclusion, would not the presumption of correctness have some bearing as well as our abuse of discretion review?
Well, as we talked about earlier, I think that in these cases, although the issue is reviewed for an abuse of discretion, it's cabined. And as we say in other contexts, yes, the trial court has discretion, but it is limited by rules, statutes, or case law. And so I think that here we have case law that limited the trial court's discretion. We have somewhat similar cases where there weren't clear indications that they wouldn't be able to follow the burden of proof, or maybe there was a recantation later on. But ultimately, as I said, I think that district courts in these kinds of cases conduct a more rigorous review of the record than in other cases. And I'm sorry, with that, I'll leave the rest of my time for rebuttal. Thank you.
Thank you, counsel.
Good morning. May it please the court. My name is Sydney D'Angelo on behalf of the appellee, Walmart. We respectfully ask the court to affirm the final judgment on appeal. I'll go in the same order that my colleague went, and I'll start with the preservation issue, because I think that this court can and should affirm on that basis alone. As this court is aware, the Florida Supreme Court in Joyner set forth a very specific procedure for preserving an objection to the denial of a cause preserving for appeal an objection to the denial of a cause challenge.
What more would you require?
An objection immediately before, in this case, an objection immediately before the jury was impaneled. And that's because, as Judge Kilvane was getting to, there was a lot of discussion in between the request for a peremptory challenge and the ultimate swearing in of the jury that had to do with the composition of the jury. The court and the parties were discussing an alternate. Plaintiff eventually said that he would rather proceed with just 6 jurors instead of go through voir dire all over again. And the trial judge may have, as in Joyner, may have taken that to be a waiver or an abandonment of the initial objection. I think the rationale behind Joyner is particularly relevant here because in Joyner, the Florida Supreme Court said, and I'm quoting, "It is a severe step to overturn an otherwise error-free trial based solely on a jury selection error. This is a single-issue appeal. Plaintiff does not contend that there were any other errors during the trial. And so especially in a case where we have this discussion after plaintiff requested the peremptory challenge, I'll take a step back. The court initially made that statement about, understanding your prior objection. The court then granted an additional peremptory challenge. So that's another instance where the plaintiff may have been understood to have been abandoning her objection to the panel. So based on the rationale in Joyner, plaintiff failed to preserve the issue for this court's review, and the court should affirm on that basis alone. I do want to address the cases that plaintiff relied upon very quickly. I didn't hear him actually address Greathouse, which is a recent Second District Court of Appeal case that we cite in our brief. And the facts of that case are very similar to here. There was a discussion there was a request for an additional peremptory. It was denied. Then the parties moved on to the alternate, and the Second District said, without a renewal of the objection at the end of that discussion, the issue was waived. We have the same facts present here. Plaintiff had cited to the court Langan, which is a Fourth District Court of Appeal case. And in that case, the court stated, "The record reflects that in denying the request, the trial court made clear that it understood the objection would have to be resolved on appeal." Again, here we don't have that. We have many facts in between where plaintiff could have been understood to have been abandoning his objection. So I'll move on to the merits. The court should affirm based just on the failure to preserve. But I think that this is also a clear case where the court should affirm on the merits. I want to start by addressing the standard of review. I respectfully disagree with my colleague that there's sort of a cabined or there's less discretion afforded to the trial court in these cases. The Florida Supreme Court held in Pagan versus State in 2009 that there is, quote, "hardly any area of the law in which the trial court is given more discretion than in ruling on challenges of jurors for cause." And that's because, as Your Honor, Judge Sood mentioned, the trial judge is the one in the courtroom observing the demeanor of the jurors, listening to their tone of voice, and the trial judge is the one that can make the decisions about whether he or she believes that the jurors are truly biased and if they mean what they say they do. So the standard of review is really important here. It's an abuse of discretion standard. It's also been described by the Florida Supreme Court as manifest error. And so I heard a lot of discussion, and there's a lot of argument in the briefs about resolving doubts in favor of excusing the juror for cause. But that's the trial court's decision. That's the standard that the trial court applies. And then this court, in reviewing that the trial court's decision, looks to see whether there is competent record support for that decision. So Judge Sood, to answer Your Honor's question, it is an abuse of discretion standard, and I think that viewing the record in that light, it's clear that the jurors, both before and after this sort of confusing line of questioning that I'll get into in a minute, these jurors stated that they could apply and would apply the law as instructed. So we look at the totality of the statements. We don't look at a single question that was posed by trial counsel. The jurors stated at the outset that they would apply the law as instructed. Plaintiff's counsel asked them whether they had any problem with the greater weight of the evidence standard. He described it as just one grain of sand that they needed to prove their case. And the jurors said they had no problem with that standard. Neither of the jurors currently being challenged raised their hand that they would have a problem applying that standard. Mr. Robinson was questioned individually on that standard, and he stated no, he did not have a problem with the greater weight of the evidence standard. Ms. Mitchell, the other juror that's being challenged, was also questioned individually about awarding pain and suffering damages by plaintiff's counsel at the outset of voir dire. Ms. Mitchell also said that she had no problem with pain and suffering damages. And then we get into this, I'll call it a confusing line of questioning from plaintiff's counsel. And Judge, I think it was Judge Makar, you started to indicate and Judge Suit, I think you did too, that these questions were really, they were equating the greater weight of the evidence standard with accepting the plaintiff's testimony as true, which of course the jury was not required to do. They were instructed at the end of the case that they were to weigh the evidence. So the first question from plaintiff's counsel says, would you want, where you're not going to have a piece of paper, it's going to be Ms. Kuhn coming in here, would you have a little concern as to the proof? Would you want to see some more proof for those types of damages where it's not a doctor bill? It's just Ms. Kuhn telling you how it is. Would you want to see a little more? He uses that phrase throughout the questioning, a little more, a little more. And of course that relates back to, will you accept Ms. Kuhn's testimony as true? That's not what the jury was required to do. That's not the standard that the jury was instructed on. And I think that's really important because in the Florida Supreme Court's decision in Matarans, the court distinguished between prejudices that are based on a juror's personal experiences, long-held beliefs, versus expressions based upon a lack of familiarity with the judicial process. And that's exactly what we have here. We have some confusion about what the jurors were allowed to do or not allowed to do. Plaintiff's counsel never asked any follow-up questions of the jurors, not Ms. Mitchell, not Mr. Robinson. He never asked why they felt that way or tried to really understand whether they had any experiences that would actually demonstrate prejudice or bias. And then, of course, we have the court interrupted and plaintiff's counsel again asked whether the jurors would want to see a little bit more, always going back to Ms. Kuhn's testimony. Then we have defense counsel getting up, and she specifically referenced that there was a little bit of confusion maybe about what a little bit more means. And she singles out Ms. Mitchell. She says, I know there was one point where you said you'd like to see more. She says, if plaintiff proves her case, would you be able to follow the law, or would it be something where if you're talking about intangible, I can't follow the law the court is giving? Ms. Mitchell says, of course, yes, I can follow the law. The same with Mr. Robinson, unequivocally.
In fact, they did follow the law because there are some intangibles.
Yeah, exactly, Your Honor. They did award some intangibles, and they awarded a much less amount of past medical expenses, which the plaintiff does not contend that any of the jurors were biased with respect to economic damages. So the verdict reflects that the jury just didn't believe the vast majority of her testimony. It was a credibility determination, which is within the juror's discretion. I think that the Florida cases that we cite in our brief make clear that the jurors' questions just don't rise to the level of requiring a cause challenge, and the trial court acted well within its discretion in denying the challenge. And so on the harmless error issue, we will rest on our brief unless the court has any questions. But otherwise, we ask the court to affirm.
All right, thank you.
Thank you.
Thank you. I just have a few points I would like to make in the few minutes remaining. On preservation, the additional strike we used against Widner did not indicate that we abandoned our challenge to Robinson, because after that, we twice objected to Robinson serving on the jury. So there should have been no doubt that in the trial court's or the defendant's mind that we maintained consistently our position on that point. On the standard of review, I think Matarans is again important because in that case, if you look at Justice Kennedy's dissenting opinion, he actually criticizes the majority for its less relaxed application of the standard of review. He says, having tipped its hat to the manifest error standard of review, the majority effectively ignores our recognition that the trial court has a unique vantage point in the determination of juror bias. And that goes back to what I was saying earlier, which is that in these kinds of cases, when there's a right to a fair and impartial jury and a lot of case law that's built up on what requires the granting of cause challenges, that in practice, there's probably a little less deference owed to the trial judges. On our failure to ask further questions of these jurors, I just want to point out that it isn't our burden to rehabilitate a juror who has indicated a bias or preconceived opinion. It is the other parties, and sometimes the courts do that sua sponte. On harm, I don't think that the defendant has established that this error was harmless. I think that what they've essentially said is picking up on something the court said in Seidler, that no reasonable jury could have found for us, so no harm on Robinson sitting on the jury. However, what they actually do is they present closing argument, or they say, as here, that they discredited our client's testimony. But that's a weighing of the evidence for the jury. That doesn't say that no reasonable jury could have found for us on the points that we're disputing. It's just that it was a hotly contested case. I think you can see that from the closing arguments. We each had evidence and testimony that supported our sides. And to simply say that, well, the jury agreed with us anyway, that's sort of circular reasoning. The question is, did this error affect the jury? And our contention is that it is. And Judge Makar, on your point that the jury did end up following the law because they awarded some damages, I think that that's not dispositive, because even if they did award some non-economic damages in the past, again, the ability to be fair, the ability to award non-economic damages based on the court's instructions could very well have led them to say, you know what, we'll give her this, but we wanted to see a little bit more. We won't give her anything in the future. And with that, thank you very much for your time.
Thank you, counsel. Thank you both. Okay, the next case on our docket is Schramm versus Adams Homes of Northwest Florida and Shoemaker and Son Plumbing, 24-0445. Let me take a moment to say, obviously, you both get 20 minutes per side. You don't have to use it if there aren't any questions from the panel. I also want to make a comment. It's typically not my practice to introduce my colleagues. Like some of my colleagues, when they're presiding, they do introduce themselves, and I've seen the wisdom today of why it is important to introduce my colleagues. It's Judge Adrian Soud. It rhymes with loud. So it's Judge Soud, and just to my left is Judge Paige Kilbane. So this is Scott Makar, not Mocker, Macker, or whatever. So with that, please proceed, Mr. Lee.
Thank you for the introduction, Your Honor. May it please the court, Brian Lee representing Robert Schramm on appeal. This case comes to the court from a summary judgment, as the court knows, and we believe that the trial court's order must be reversed for multiple reasons, because we believe that every step of the analysis that was done by the trial court was in error. We start way back at the beginning from the analysis that was done of my client, Robert Schramm, whether he was a trespasser, whether he was a licensee, whether he was an invitee on the property. The trial court found that, and the only way it could have found this would be to find it's undisputed that he was on Adams Homes property, which was right next door to his. They had a new build going there for a construction project. The trial court had to have said it was undisputed factually that my client was on their property when this fall happened into the hole or depression that was there, where it is very clear from the facts, and actually the trial court even says that it's unclear as to where Mr. Schramm was, because the hole and the depression were sort of in the back corner and it's sort of right where property lines merge.
Well, in fact, the silt fence, there was let me get the facts right. There's a silt fence put in, right? And that would be right along the property line, I presume.
It did, Judge. There's a little bit of back and forth as to, because the silt line, the soil fence that was there was actually taken out as well. And so I think the evidence is fairly clear that the hole and depression that he fell in started on the Adams Homes part of the line. At least that's the best we know.
Well, painting the picture, there's a silt fence, and then there was and it got knocked down or something. It wasn't performing its function.
Right.
Apparently, I don't know. But and then the plumbing folks come in and they're digging, and the property owner is looking at all this going on, seeing there's a problem. So he decides to put some flags up. And he starts walking over there, and then and he didn't fall in the hole, but on his way to the hole, near the perimeter of it, it gave way and he fell 4 feet down into the hole. That's sort of I don't know if it's uncontested or undisputed facts, but that's sort of what's kind of going on here. We're not quite clear where the property line is.
That's correct, Judge.
Okay.
And also, you're right that the client didn't actually sort of trip and fall into the hole. It was the ground that was around it, we believe, was compromised because of the fact that they were doing all this work. They were doing plumbing, they were doing sewer lines that were going in.
What were the injuries?
I'm sorry, what?
What were the injuries sustained?
The injuries he had, it was primarily leg injuries, knee, those ankle, those types of injuries that were there from the fall in the hole. As he went forward.
Breaks, what was that?
I think it was sprains. I think it was broken as well. His ankle, and so there. I can look for you, Judge, and see and find out. Yeah, that's not something I focused on, but I find that out for you, Judge, from the record, because it didn't really get into the injuries at that point. We know that he was injured when he fell in, and so by the trial court determining that he was on Adams Homes properties, where the facts, frankly, don't lend themselves to that, or at the very least are unclear, then from the beginning, the trial court is operating what we believe was on a flawed presumption. That he was a trespasser. They didn't owe him a duty. The only duty they owed him was this heightened standard to trespassers, that they couldn't do something intentionally.
I'm sorry, wasn't there some testimony that he went and tried to get the contractor to do something about it? He tried to contact him, and they wouldn't call him back, or they? That's
correct. No, he contacted the contractor, Adams Homes. He testified to it, and they didn't do anything. So he told them about the hole. I guess this was a hole. This wasn't something that formed within a split second. It was something that was forming. He contacted them about it, so they knew about it. They didn't do anything, and so as a property owner, homeowner, I guess for himself and others, he went out there to try to put the little flags, as you mentioned, Judge. It was before he got there that he was not aware of the ground that had been compromised below it. And so that ground gave way. That's what caused the injury. So we start from there, which we think just that part is error. Then we go to the part where we're talking about the duty to warn. Duty to maintain. I'll get to the maintain later, but the duty to warn part, there is, the trial court found that, well, even if he was on his own property, he knew about it. It was an open and obvious condition. That's not quite what Florida law says. Florida law says that, yes, there is this concept of an open and obvious condition. It's sort of been subsumed within the comparative negligence part of the law. You can, the jury could say, you should have some liability for that. But what it doesn't do is it doesn't allow a judge at summary judgment to get rid of the entire case. Because part of the law, and I've cited to it in my brief, is that When a landowner, property owner, contractor in this case, possessor of land knows that there's a condition, even if it's open and obvious, they knows that that could cause injury to others, they have a duty to guard against that. So there's a duty under the law, even if there's an open and obvious. The classic example, Judge, is, you have a big sinkhole in the middle of Walmart that opens. Walmart can't just say, well, everybody knows about it, so if somebody falls, we don't have any liability for that. They do, because they know that, okay, people might be transversing in the area. It just so happened that it was the property owner next door that did, on his own land, we believe, but the duty is still there.
Right,
so,
and counsel, I apologize, with the Walmart example, I guess maybe, I would agree that the law is not so clear for open and obvious, and there is that foreseeability component there, but here we have that, you're not a business invitee because you're not in the middle of Walmart, but the order seems to be sort of internally inconsistent, with whether or not he was an undisclosed trespasser, but then we don't know where he is by the order itself. So do you think that matters? Does it matter? You didn't really challenge his status as a trespasser on appeal. So are you saying that he was in the zone of risk? That seemed to be the argument, or what are you proceeding under here?
Well, we did say that his status was unclear. So to that extent, we are challenging the ruling, because the trial court ruled as a matter of law, basically, that he was a trespasser.
Yes.
We say within the briefing that status was unclear because there was material facts that were in dispute on that. And so we are challenging that part, but I think I hear what you're saying, Judge Kilbane, is even if he's a trespasser, let's just say that there was undisputed evidence that said that, it still doesn't get there. Because in that situation, the hole in depression, and really more specifically, the ground underneath, started on their side, started on Adams Home's side, and came into Mr. Schramm's side. They have the duty, under the law that we've cited, to make sure that the things that they're doing on their construction site doesn't hurt people outside of the site.
That's the building code you rely on.
It's the building code, and it's also the cases, like I think it's the Worth case that I've cited, where it's not just a duty of care that a construction or an owner has on a construction site within the site itself. It's around it as well. And so when things that are being done on the construction site affect things outside of the construction site, they have the duty of care for that. Maintain, warn, all the types of things that we see under the law. And
Is maintaining a silt fence.
so it's maintaining a silt fence. Maintaining the ground, that's if this ground had penetrated so much so that it went to the house and it basically causes Mr. Schramm's house to fall down. I don't think there would be an argument from them that, well, we're not liable for that because that's really his house. It's not on our property. They caused that to happen. It's no different than causing something to happen that compromises the ground on Mr. Schramm's property that causes him to fall into it, literally.
As we sit here today, are the facts so definitive and clear that the injury occurred on the neighbor's property, not his property?
I don't think they are, Judge. I think when you look at the record, Mr. Schramm talks about coming from his property and sort of approaching the hole on his property, and that the hole had already he thought, kind of went into his property, and he's trying to do that's all, he's pretty clear that he's saying that's all on his property, that he's doing that. Now, there was some testimony about, well, are you sure? Do you know where your property lines are? And he, I think to his credit, said, well, I don't know where the property lines are, but I mean, I'm going there as to where it is. There was not, so he has that testimony. Adams Homes then comes in and says, well, he must have been on our property. I don't really know where that comes from, frankly. I guess the only thing it could come from is that, well, the hole was on our property, which is kind of a weird way to try to say you're a trespasser. But there really wasn't evidence there, and the court, I think, doesn't need to go any farther. I think Judge Kilbane, you talked about or maybe it was Judge Makar, you talked about the inconsistency within the trial court. There was. The trial court literally said, well, I think that's not undisputed. I think there's a genuine issue as to where he was. But then went the other side and said, but it doesn't really matter. Well, we think it does, Judge. So there's multiple parts, like I said, from the beginning, that the trial court was inconsistent. The court made conclusions of law that were not supported by the facts. And when you get to the end of it, it's error. Cumulative, singularly, all together. So we believe that is why the court should reverse the order. I know have more time left, but unless the court has any questions for me, I'll sit down and reserve the rest of my time. Thank you.
Good morning, may it please the court. Teresa Savone on behalf of Adams Homes of Northwest Florida. This court should affirm the trial court's order granting summary judgment in favor of Adams Homes. Judge Kilbane, I'd like to start my argument with a question that you posed to my colleague on the other side. You noted that he as in Mr. Schramm, was not a business invitee, and that's correct. He was not a business invitee. He entered onto the property, assuming this is Adams Homes property, without Adams Homes knowledge or permission, and Adams Homes never learned that Mr. Schramm was on that property within 24 hours preceding, and that's the definition of an unknown trespasser.
Well, counsel, what's the record evidence that we know that Mr. Schramm was actually on Adams Homes property and not his own?
Admittedly, the evidence is not clear where it is, and that, as you indicated, that is in the trial court's order.
Is that not material to our determination at this stage?
No, Your Honor, it is not. The location of where he fell is not a genuine issue of material fact. It would be
How can that be?
How is that possible?
How does that not directly affect the duty of care owed if he's on his own property? Does that not give rise to an argument that failure to maintain the fence or other aspects of the construction site caused soil on his property to give way, and that's what he fell into? I don't understand how that's not a material fact.
Because if we look at the third amended complaint, Judge Soud, the allegations are for premise liability, and the allegation at page 119 in the record is that plaintiff was an invitee on Adams Homes' property. So I know my colleague indicated that, well, we don't know where Adams Homes came up with the fact that the hole was on Adams Homes' property. This was how it was pled. This isn't a construction defect case. There are no allegations related to the building code, and I know there was discussion about that in my colleague's brief.
Was there no claim for negligence?
There was
in
a
the
claim
third amended complaint?
Yes, Your Honor, there is one. There are two allegations against Adams Homes, and one is for premise liability, and one is for negligence. I acknowledge that. The invitee, however, and when we say where does it come from with where the hole was located, it was because of how the allegation was brought. So this is not a failure to comply with the building code. This is not a failure to go through the property. There are no property allegations. The allegations are that this is a premise liability, that Mr. Schramm was an invitee on Adams Homes property. And there is no evidence that he was an invitee. And Mr. Schramm testified that he essentially was not an invitee.
Did the negligence count say that as well, that he's an invitee?
I can double check that, but I do know that on count one for the premises liability, Your Honor, I do know that that indicates that he is an invitee.
Well, and I'm looking at page 122 of the record, which is count 2 of the third amended complaint.
Yes, Your Honor.
And at the bottom of that page, the allegations include paragraph 20 sub C, negligently failed to train or adequately train its employees to properly maintain its construction site, which compromised the safety of the plaintiff as he walked on or around the construction site. It seems to me, and I could go on reading further that negligence, it seems to me that perhaps that properly pleads and places into issue whether or not the failure to maintain the construction site causes a degradation to the plaintiff's property, depending on where he was at the time of his fall. And it seems to you seem to concede that that's actually not entirely clear as to where exactly he was on whose property at the time of the fall, which seems to me a quintessential genuine dispute as to a material fact, I go back to where I started a minute ago. Given the totality of the allegations within the third amended complaint and the record evidence as it was presented to the trial court, how this is not a quintessential jury question.
And it may be more a quintessential jury question, maybe on that count too for negligence, and maybe not on the premise liability action. And maybe that is the question. And to be candid with the court, and this is a little outside of my brief, but to answer your question, a premise liability case on count one indicates invitee. I acknowledge, Judge Sowd, at page 122 in the third amended complaint that it does discuss that. And I think where the trial judge's order focuses is on the invitee status.
But the summary judgment was as to the entire case, right?
Correct, Your Honor.
So are you conceding error on the count?
I'm not conceding error.
Sounds like it.
I'm not.
Okay.
I'm standing on all the arguments in my brief, but I want to address Judge Sowd's questions that were posed to me and to be entirely candid with the court. And I'm not trying to present anything inconsistent with my brief, and I do stand on my brief for the arguments. And I think the other concern within my answer brief was that the allegations and the arguments in my colleague on the other side's brief was that these are passing statements and that there is a burden on appeal. And that is an underlying theme within my answer brief. So to stand here and make conclusive statements in a brief is not sufficient for a burden in terms of prevailing on appeal. That is understanding what the standard of review is and understanding that the trial court's order does come with a presumption of correctness as well. But to the extent, and as focused on in my answer brief, Mr. Schramm was not an invitee. He was an undiscovered trespasser to the extent it was on Adams Homes land. It is our position, as indicated in our answer brief, that it is not a genuine issue of material fact where it was located. I understand the court's position on that, and I do acknowledge that, Judge Sowd. I also acknowledge, however, that this was an open and obvious condition.
What was open and obvious about a piece of land that collapsed downward? No one would have known it happened unless they stood on it.
Mr. Schramm testified that he saw a hole for about a month in advance, and that he wanted to go see it and put flags around it. So his testimony was that he cautiously approached it. So it indicates, what the summary judgment evidence indicates, is that he was in a superior position to know what perhaps the status of the surrounding land. And I think what both parties agree is the hole had to have been on Adams Homes property because it's the construction site. I think we all...
He didn't fall in the hole, did he, counsel? He fell in ground that collapsed. There was green grass, and he fell under it. So the fact that the hole may very well be open and obvious, but how, as a matter of law, is falling through green grass, I guess, I don't know how far away from the actual hole, how is that open and obvious as a matter of law?
I think based on Mr. Schramm's testimony that he was aware of the hole, he was watching the hole, he was looking at the hole, and he knew when he was approaching it, he was doing it in a way that it was clear when he said, I cautiously approached this hole, or I cautiously approached this area.
So if he ran to the hole, that would indicate that he didn't know? So because he was cautious and thought, wow, the hole's getting bigger, maybe I should go, so no one gets injured, that somehow makes it open and obvious as a matter of law?
I think based on the facts and circumstances of this case, I think it is clear that Mr. Schramm was aware of the hole and that he was watching it, and that he even described why he thought the hole was becoming a type of figure, or how it was getting washed out, or what he thought should have been done. So it was clear that he was paying attention to this. I understand that that may not be the facts and circumstances of every case. I do acknowledge that, and I do acknowledge that this may be a different type of case than others, but this, in Mr. Schramm's testimony, he was aware of this hole, he knew of it, and he was aware of it for a month. So that is exactly what the trial court looked at and said, this is what we're looking at to determine that this is open and obvious, because someone who can have their normal senses and perceive it. It's no different than if you have a landscaping feature, where landscaping features are determined to be open and obvious.
So a planter, you're saying it like that case, I assume you're speaking of, that was a planter, correct? like a palm tree planter?
I'm speaking generally, Judge Cobain.
Okay, so you think that this is similar to landscaping? Is that the best case you think that supports the position that this is open and obvious as a matter of law?
I'm saying that based on Mr. Schramm's testimony, it follows the case law that says if someone can perceive it with their natural senses and observe it, then yes, that is open and obvious. This is also not a situation where he had to take that route. He chose to take the route. He voluntarily went to it knowing that there was a hole. So my understanding of the evidence is not that you have a hole and then 20 feet behind he falls into it. This isn't an instance where all of a sudden it's a sinkhole. It's not that there's these unknown parameters where he takes a step, he thinks he's 50 feet off of a hole, and all of a sudden it gives way.
But is it akin to that? I mean, if I recall the record, and please correct me if I'm wrong, but if I recall the record correctly, he has a shovel in his hand.
Correct.
Designed to kind of probe the ground to make sure it's firm underneath him.
Correct.
And as he approaches an area that still has grass on it, it gives way. That's his testimony. And then there's some lacking clarity as to precisely where he may have been and things of that sort. But I mean, the picture that's painted, it seems to be kind of like as he's probing, in order to, with flags, mark the perimeter of unstable ground, he then falls. If grass is growing and covering ground beneath that is unstable, contributing to a fall, as alleged, we're not making that determination, but as testified to based on allegations within the complaint, how, and I think I'm building, frankly, on Judge Kilbane's question, that can't be open and obvious as a matter of law. That would seem to me to need to be resolved by the jury. That's what I keep grappling with as I reviewed the trial court's order, as I reviewed the record in the case. That which is open and obvious, if it were undeniably undisputed on a whole on the construction side, that may be one factual scenario, but it just doesn't seem that factual scenario is presented in the record before us, and that's what I'm wrestling with.
I understand, Judge Soud, and again, I'm resting on my answer brief where we have argued that Mr. Schramm, and you are correct, he approached it with a shovel, but he approached it with the shovel knowing that he himself thought this was unstable ground.
Is there grass growing on the construction site?
I know that there are very black and white blurry pictures in the record. I know that there is grass, I can tell from that picture.
Okay.
To be 100% candid, cannot advise where there is grass or there is not grass.
On the Adams construction side of the line.
I cannot tell. I personally cannot tell from the pictures. But there is grass.
Did not an Adams construction employee testify that even he couldn't testify where the property was in a given picture?
I believe.
In other words, as it pertains to where a picture showing there was not a way for at least that one employee to say the property line is here such that it could be determined whether grass is growing or the like.
Right. It is what we know from the record is that, and even in the judge's order, we know that the property line, it is not clear. Mr. Schramm doesn't know where he was. He even testified he thought he was on the property. He wasn't sure. Obviously, if he falls into the hole versus unstable ground that may have been further off of the hole is on Adams Homes property. That we would know because that is where the construction and the plumbing was done. That is where the pipe was in the hole. So the hole has to be on Adams Homes property. He's not alleging that that hole they dug in a wrong place. So we know that the hole has to be on it because it is an active construction site. Now, where he fell in relation to that hole, I don't think anyone can say it is definitively on this. I do know that the argument related to the invitee versus the unknown trespasser goes to the premise liability, as in count 1 of the third amended complaint, where it was pled that Mr. Schramm was an invitee.
I'm getting a little confused now. Was this hole dug, or was it because of the overflow of water, or was it because of the plumbing, or why was there a hole? Put aside the collapsing sod.
Right.
Why is there a hole?
My understanding is that there was a hole because there was plumbing that was performed by the subcontractor and that there was a pipe within the hole.
Okay.
And it is my understanding that there was water or rain. According to Mr. Schramm, he believes it's because the hole wasn't properly backfilled, was his statement, that's why he believes that the hole got bigger. So there was a hole for plumbing on the construction site. So whether he fell in the hole or around this area, I think is where the question is.
Were there leaky pipes or something that was undermining? I'm trying to envision what happened to cause the sod to be undermined.
I am not aware of any evidence or testimony that there was a faulty pipe, leaky pipe, a crack in a pipe or sewage line or a water line that was being put in to the construction site.
Going back to the theory of the case with the 2 counts, my recollection, I could be wrong, the duty to the open and obvious doctrine basically can nullify a claim basically for a duty to warn type of situation. You don't have to put up a sign, warning, the sidewalk has a 6-inch ledge. You know, it's open obvious. So there's no duty to warn about that,
Right.
the duty to warn theory. But that doesn't mean that all claims for negligence, meaning make the property safe, go away just because there's an open and obvious problem, open and obvious risk, let's put it that way. Isn't that the case?
Well, I know that when you have an invitee, and whenever we talk about premise, we have to look at the status of the land. An invitee you have a duty to warn, a duty to maintain. And I understand that one can go away and one can remain. But this case, there is no evidence that he was an invitee. And I think that's where the discussion was because, and I don't.
But that goes back to the fundamental issue of whose property was he on. If he's on his own property, he's clearly an invitee on his own property. So, I mean, he's entitled to be there, let's put it that way.
He's entitled to be on his property, absolutely. Whether he's now, but can he claim an allegation or a cause of action against Adams Homes, that he was an invitee on Adams Homes land, and then allege that it wasn't on their property? I'm not sure about. And I think that's maybe where any confusion in this case lies, was that the allegations, at least as to count 1, is that he was an invitee. So I know that there was the discussion of where did this come from.
Isn't this just a classic negligence case, comparative negligence case, where the jury says, okay, this hole was dug, it had some problems with it. He went over there, maybe he shouldn't have. We're going to balance it out and, apportion negligence. Isn't that this a classic case of comparative negligence?
Judge Makar, I disagree for the reasons stated in our answer brief, which is that there was no duty owed by Adams Homes and that he was an unknown trespasser.
Was there any evidence that he thought he was putting flags up not just to warn people, but also to demarcate the risk and also perhaps to protect his own property?
I don't recall anything that he was doing it to protect his own property. I believe his testimony was that he was placing the marking flags because he didn't want someone to fall into the hole, which means he understands and appreciates with his senses where the hole is. So that's why, and I think what our discussion, Judge Kilbane, was the discussion of where if the land gave way, his testimony doesn't indicate that it gave way so far away from the hole that it says, well, this clearly had to have been on his property. It seems more that this is pulling closer to or on the construction site.
But how can we say that as a matter of law at the summary judgment stage if there's not record evidence of where he fell? And no one is disputing that he fell into the hole. He didn't. It's not, I don't think, as far as I could tell in the record, it's not like he walked up to the hole and jumped in and then, or fell into the open hole. He was walking up to mark the edge, and at some point before the edge, the ground collapsed underneath him. So that's my question. As a matter of law at this stage, where we don't know if that collapse was before the hole, like how far before the hole, where it was, whose property it was on, I'm unclear how, as a matter of law, that determination is made with the record evidence in this case.
And I understand. And again, I do want to rest on my arguments in the brief, and I'm not trying to present any argument that is different than those that have previously been presented. So it is our position that this hole was known. He voluntarily went to this hole. He knew of it for a month in advance, and he was aware of it growing. Based on that, he understood what risk was there. And if he was on Adams Homes property, then he was an unknown trespasser. And to the extent that if he was on his property, we do not believe that any question is a genuine issue of material fact that needs to be resolved by a jury. We also stand on the position that these arguments and positions were not fully briefed to the extent that it would meet a burden on appeal by Mr. Stram. And for these reasons discussed here today and those in our answer brief, we ask this court affirm.
So Adams Homes doesn't own the property, correct?
Adams Homes does own the property.
Does own the property?
Yes, Your Honor.
Okay. I was just,
Yes.
is Adams Homes indemnifying the plumbing company? Because they're not here today. They were part of the summary judgment.
I am not aware of the answer to that,
Okay,
but
so it's okay. So I'm just trying to figure out where the plumbing company fits in, because they're not here. They didn't file a
Correct.
brief.
correct.
Okay. And you're not, they didn't, okay. You're not representing.
I'm not here on behalf of the plumbing
Okay.
company, Judge Makar.
Thank you.
Thank you.
Couple of follow-ups. Judge Makar, I did look, and the injuries that I was thinking of were an Achilles tendon injury that he had on workers' comp, and I think that had been aggravated. But the main injuries that he had was his right shoulder. I think partly because of the shovel, he kind of used as a brace, and that hurt. We had surgery from that. He also had low back injuries as well, and hip injuries from sort of falling into the grass. The other question I wanted to, right at the end, about the plumbing company. In the record, there is a contract that is between the two, and there is indemnification in there. However, there also is certainly that the owner has non-delegable duties, right, to maintain and the property, and so we didn't choose to bring the plumbing company into the appeal, although they were part of the summary judgment, for that, but it was really more focused on the owner. The testimony, I think, that the court read or that was alluding to, it's pretty clear that this was not a step into the hole, that this was a falling through grass that was as he was walking towards, and I think the record also, I think it's page 296, I believe I had, of the record talks about the reason why he was doing it was that he didn't want his lawn maintenance people, and one of the reasons. He talks about, I wanted to put little flags because I didn't want my own lawn maintenance people who were mowing my lawn to fall in there to see it. So it's pretty clear. I don't think this was a situation, I don't think it was suggested, but this wasn't a situation where he's literally going onto the construction site and messing with a hole that he knows is on a construction site. That doesn't, frankly, make any sense. Why he would be doing that. He's doing this because of the fact that he thinks it's on his side. He's worried about not only his safety, but workers that could be around the area that he's hiring, as well as he's told them about it, and they're not doing anything. So I do agree, at the end of the day, this is going to be something that the jury's going to have to decide. They're going to have to decide how much negligence Adams Homes has, if there's any negligence that Mr. Sharam has, but they should get to decide it.
Would you be willing to address your colleague's argument concerning the absence of record as evidence as it pertains to the invitee status on count one?
Sure. As to the premises liability, yeah. So they certainly, as you can kind of guess from the way the third amendment complaint was done, they are sort of alternative pleading counts. If he was on, if the evidence was that he was on the property, that we would be saying that he's an invitee because they know about him. Right, there's evidence that they know about him as the property owner next door. There's case law that we talked about where, if you know that people kind of are around the construction site, you still have that type of duty. And so the facts of the case, we believe, could lend themselves to, frankly, either theory. That either he's an invitee on a sort of a traditional premises liability that could go under count one, but we also, as Judge, you mentioned, we included just the general negligence part of it. And that had to do with the fact that there was a condition that was created by them or for someone that was working for them, which ultimately flows to them, that affected his property and ultimately caused his injury. That's a pure negligence claim. We've pled that. I don't think there's any argument that was not pled correctly or that could not have been brought to a jury. The judge just didn't allow it. He decided that because he thought that it was a trespasser, all the counts go away. And as we've already discussed, we believe that that was error. So we would ask the court to reverse on all counts and allow a jury to decide this.
Is there any evidence that there was an implied license to go on the property for your client to?
There's certainly, I don't, thinking through it, obviously there was, it's next door neighbors, literally. And there's certainly was the notice that was given to multiple people. I think actually he talked about giving notice not even to the owner, but the contractor, to the HOA association, I want to say. And certainly when you start getting into whether someone's I think it's an uninvited licensee or an invitee. There's all sorts of permeations there. The facts certainly bear out those kind of situations. And when the facts are unclear as to the status of someone, a court can't determine that. I think that's the bottom line we have in this case. Thank you, Your Honor.
Thank you. Thank you both for your arguments. We will be in recess.